Alright, listen up. And welcome to my channel. Today we're talking about the legal documents every senior citizen must have. Don't put this off. If you do, your family will be left with a mess, not you. These documents are your voice when you can't speak for yourself. They protect your assets, your dignity, and your family's sanity. I'll walk you through the essentials: your will, healthcare directives, and more. By the end, you'll know exactly what to do to get your house in order. Let's get started. The last will and testament, don't avoid it. It's one of the most important documents you'll ever create, yet so many people put it off, thinking it's only for the wealthy or the elderly. The truth is, a will is for anyone who cares about what happens to their loved ones and their belongings after they're gone. It's your voice, your final word, when you're no longer here to speak for yourself. Without a will, the state decides who gets your property, not you. The law steps in and distributes your assets according to a formula that may have nothing to do with your wishes or your family's needs. This process, called intestacy, can be slow, expensive, and deeply impersonal. Your treasured possessions, your home, even family heirlooms could end up in the hands of people you never intended. That's a recipe for family fights and chaos. When there's no clear direction, emotions run high and misunderstandings can tear families apart. Siblings may argue, relatives may feel slighted, and old wounds can resurface, all because your wishes weren't put in writing. Be specific. List your assets, name your beneficiaries, and make your intentions crystal clear. Don't leave anything to chance. Include everything from your home and savings to sentimental items like jewelry, art, or family mementos. The more detailed you are, the less room there is for confusion or dispute, and assign an executor you trust. This person will carry out your wishes, handle paperwork, and make sure everything is done properly. Choose someone responsible, organized, and willing to take on the task. Talk to them in advance so they know what's expected. If you have minor children, name a guardian. This is one of the most critical decisions you'll make. Think carefully about who will love, protect, and guide your children if you're not there. Don't leave this up to chance or the courts. Otherwise, a judge will decide. And while judges do their best, they don't know your family like you do. The outcome may not reflect your values or your children's best interests. Sign your will properly. Don't scribble it on a napkin. Each state has its own rules about what makes a will valid. Usually you'll need witnesses and sometimes a notary. A hastily written note might not hold up in court, leaving your family in limbo. Go to a lawyer and do it right. It's a small price for your family's peace of mind. A professional can help you avoid mistakes, update your will as life changes, and make sure your wishes are legally binding. Think of it as an investment in your family's future security. A will isn't about dying. It's about caring for your loved ones after you're gone. It's a final act of love and responsibility, ensuring that your family is protected, your legacy is honored, and your wishes are respected. Don't let your legacy be confusion and resentment. The pain of loss is hard enough. Don't add uncertainty and conflict to the mix. Your family deserves clarity and peace. It's the first step in getting your affairs in order. Stop procrastinating. Write your will. Make it clear. Protect your family. Take control of your legacy today and give your loved ones the gift of certainty and peace for tomorrow. Imagine waking up one day and realizing you can't manage your finances because of a sudden illness or an unexpected accident. It's a scenario no one wants to think about, but it happens more often than you might expect. Life can change in an instant, and if you're not prepared, the consequences can be overwhelming for both you and your loved ones. Without a clear plan in place, your family could be forced into a lengthy, expensive, and emotionally draining court process just to gain the authority to help you. This legal process, called conservatorship or guardianship, can take months and cost thousands of dollars in legal fees. Meanwhile, your bills might go unpaid, your investments unmanaged, and your financial life could quickly spiral out of control. The good news is you can avoid all of this with a simple but powerful legal tool, a durable power of attorney for finances. This document lets you choose someone you trust, your spouse, an adult child, or a close friend, to step in and handle your money matters if you're ever unable to do so yourself. They can pay your bills, manage your bank accounts, and make sure your financial obligations are met. But this is a big decision. The person you appoint will have access to your bank accounts, investments, property, and more. It's essential to choose someone who is not only trustworthy, but also responsible and organized. Take your time, talk it over with your family, and make sure your chosen agent understands your wishes and values. And remember, life is unpredictable. That's why it's wise to name a backup agent, someone who can step in if your first choice is unable or unwilling to serve. This extra layer of protection ensures that your finances are always in good hands, no matter what happens. You'll also need to decide when your agent's authority begins. Do you want the power to take effect immediately, or only if you become incapacitated? Each option has its pros and cons, so discuss it with your attorney and your family to make the best choice for your situation. Most importantly, if you have any doubts about the person you're considering, trust your instincts. If you don't feel completely confident in their honesty and judgment, it's better to choose someone else. This is your financial life. Don't take unnecessary risks. With a durable power of attorney, you can rest easy knowing your bills will be paid on time, your investments will be managed, and your assets will be protected, even if you can't do it yourself. It's a simple step that brings enormous peace of mind. Most importantly, it spares your family from the stress and confusion of trying to sort out your finances in a crisis. Instead of facing legal nightmares, they can focus on supporting you and each other. Don't leave your financial future to chance or hope that things will just work out. Take control now, before it's too late. Meet with an experienced attorney and get your durable power of attorney for finances in place. It's a straightforward process that can make all the difference when life throws you a curveball. This document is a cornerstone of any smart estate plan. Protect yourself and your loved ones. Get it done today and enjoy the peace of mind that comes with being truly prepared. Now, your health. If you can't speak for yourself, who makes medical decisions? A healthcare power of attorney lets you name someone to be your medical voice. Without it, doctors may turn to the wrong person or even the courts. Pick someone level-headed who understands your wishes. Talk to them about what you want, aggressive treatment or comfort care. Name a backup agent in case your first choice isn't available. This is separate from your financial power of attorney. Give your family clarity, not confusion in a crisis. It's an act of love. Get it signed. Let's talk about end-of-life care, a living will or advanced healthcare directive. This document spells out your wishes if you're terminally ill or permanently unconscious. Do you want life support, feeding tubes, comfort care only? Your living will guides your healthcare agent and protects your family from agonizing decisions. Be specific about what treatments you want or refuse. Reflect your values. There's no right or wrong, just your choice. Make sure it's signed and copies go to your doctor and agent. Don't lock it away where no one can find it. A living will is not morbid. It's a gift of certainty. It keeps your dignity and control. Spare your loved ones the pain of guessing. Put your wishes in writing. Don't forget the HIPAA authorization form. Without it, even your healthcare agent may be denied access to your medical info. This form lets you name who can get updates and talk to your doctors. It's essential for informed decisions and smooth communication. Name everyone you want in the loop: agent, spouse, kids. Sign it, give copies to your doctor, hospital, and the people you name. Take a copy when you travel. It's a simple step that prevents delays and confusion. Don't neglect it. Your will doesn't control everything. Beneficiary designations on accounts like life insurance and retirement plans override it. These assets go directly to whoever you name, skipping probate. The problem? People forget to update these forms after life changes. An outdated beneficiary can mean your money goes to the wrong person. Audit your accounts. Check every beneficiary designation now. Make sure they match your current wishes. Name contingent beneficiaries in case your primary choice is gone. For minors, consider naming a trust, not the child directly. Talk to a financial advisor if you're unsure. Keeping these updated is as important as having a will. Don't let a simple mistake ruin your plan. Check them today. Sometimes when it comes to planning for the future, a simple will just doesn't cut it. Many people assume a will is all they need, but the truth is, it often leaves gaps, especially if your life or finances are a bit more complicated. If you own significant assets, have property in more than one state, or want to make sure your wishes are carried out exactly as you intend, it's time to consider a revocable living trust. This tool is especially valuable for those who have worked hard to build wealth or have family members spread across the country. Think of a trust as a private legal container you create and control. You place your assets, like your home, investments, or even family heirlooms, into this trust, and you decide exactly how and when those assets are distributed. While you're alive and well, you're in charge as the trustee. If something happens and you become incapacitated, your chosen successor steps in immediately. No court intervention, no delays, and no confusion for your loved ones. When you pass away, the assets in your trust bypass the lengthy and often expensive probate process. Instead, they go directly to your beneficiaries, just as you've outlined, quickly, privately, and efficiently. This is a game changer if you own real estate in multiple states. Without a trust, your family could face separate probate proceedings in each state, which can be costly and time-consuming. A trust also gives you the power to set specific conditions for your heirs. Want to make sure your children finish college before inheriting, or provide lifelong support for a loved one with special needs? A trust lets you do all that and more, offering protection and peace of mind. Setting up a trust is more complex and can cost more upfront than a simple will. You'll need to work with professionals and transfer your assets into the trust, which takes time and effort, but in the long run, it can save your family money, stress, and legal headaches. Not everyone needs a trust. If your estate is small or your wishes are straightforward, a will might be enough, but for those with blended families, business interests, or unique circumstances, a trust can be an invaluable tool. The best way to know if a trust is right for you? Talk to an experienced estate planning attorney. They can help you weigh the pros and cons and design a plan that fits your life and your goals. A revocable living trust is the most comprehensive way to manage your assets, giving you control now and protecting your loved ones later. It's about making sure your legacy is handled exactly as you want. With a trust, you can plan for both incapacity and death in a single powerful step, ensuring your wishes are honored no matter what happens. If your situation is complex or you simply want the ultimate peace of mind, consider a trust. It's the control freak's tool for a reason. It puts you in charge every step of the way. We've covered wills, powers of attorney, living wills, HIPAA forms, beneficiary designations, and trusts. Don't just watch, take action. This isn't a DIY project. Laws vary and your needs are unique. Meet with a qualified estate planning attorney. Do it for your loved ones. Share this video with family and friends. Everyone needs this info. Procrastination is the enemy. Planning is an act of love. Make the appointment. Don't wait.